I want to talk about 3 speed tips that I recommend for landlords whenever trouble happens. You have a lease violation. Sometimes speed is your best friend. Sometimes we get into a false mindset that when things go wrong, those things should go on for months and years, believe it or not, for some landlords who just have a lot of patience. And what I'm not advocating here is that you lose patience. Patience is a virtue and patience is a good quality, but you also want to make sure that you are approaching your landlording business from a landlording perspective. And sometimes the element of speed is crucial to that. And so I want to talk about 3 things, 3 areas of landlording where speed comes into play. The first one has to do with when to send notice of that violation. And that should be very, very quickly. If you're waiting longer than 7 days to send a written notice, you're probably waiting too long. I would say that within 7 days, you have sent a notice to your tenant of whatever the default is. Is it late payment because they paid on the 3rd? You accepted the rent, but it was technically late. If your rent is due on or before the 1st day and it's paid on the 3rd, you may just want to remind your tenant in writing that the due date is the 1st or before. Now, a tenant who's going to get bent out of shape about this probably is going to indicate to you that they don't like following the rules, or they don't like being reminded when they have failed to follow the rules. That itself is a red flag. And for any of you who watched my red flag video earlier this month, you can tell that these are indications of future problems. Everybody else is just going to roll with it. They may even apologize and say, oh, you know what? That slipped my mind. It won't happen again. No problem. And the truth is, for the people for whom it is no problem, you will get no problems. For those who do have trouble hearing, hey, they paid rent late, they're probably going to do it again, and you may use this as the seed for a future termination, whether that's with an actual eviction or just at the end of that lease, you know this is not somebody you want to keep. And so by recording a record, by quickly sending that notice of default, you set yourself up for success and curtail a potential loss of rent or an extended relationship with somebody who is just not a good fit. Again, the fact that you're calling them on it may increase tension. It may make things just a little bit uncomfortable, but what it's likely also to do is either A, prevent it from happening either again or as badly as it might have otherwise, or force the issue and alert this tenant, you know what, I don't like the way this is going because I love paying my rent late. Maybe I need to leave. And that may end up being the best thing for you. But rent payment is only one of those things. Commonly, landlords come to me after months and months and months of other lease violations that they simply have not issued notices about. So those might be maintenance of the property. Maybe they're leaving things. Their kids leave bikes and big wheels and toys, or the adults leave all sorts of things out in the yard. And maybe the HOA is sending notices, or you go by and you just don't like the way they are treating the grass or the shrubs, or the way they just kind of in general leave the property in bad shape. That should be met with a written notice. As soon as you see it, you should be drafting a notice and delivering it to your tenants. Other things might be things like the way that the property is being maintained. Maybe you go inside and you see actual damage. There's a hole in the wall that shouldn't be there. There's a broken cabinet door that wasn't broken when you let them into the place. Maybe the air filter hasn't been switched out in 8 months. Notice every time. Don't delay sending notice. Don't think it's enough just to send a text. Make sure that your written notice falls in line with your lease agreement. So if that means that you can only notify them by email or in person or by certified mail, do one or all of those things, but make sure you don't deviate from that list, right? If you're just saying it verbally, it honestly isn't enough. It doesn't make the same impact, and it certainly doesn't serve as future evidence in the event you have to use it as a basis for either termination or eviction. The common things where tenants are going to be in violation of their lease are going to be with occupants and pets. So if it's not mismanaging the maintenance of the property, it's going to be with who they invite onto the property. And sometimes that's an illegal pet, and sometimes it's an unauthorized occupant. You have to be on top of this. So many times landlords just kind of let it slide. Well, it's the boyfriend. She kind of mentioned a boyfriend before, and now apparently he's moved in. Well, when did that happen? I don't know, like 8 months ago. That's way too long. At that point, it's no longer an issue that you can likely raise as a basis for eviction, especially if that's the person who's causing more trouble than the actual tenant. You'll want to address these things early. And if it turns out that that person is willing to sign the lease and they're willing to undergo a background check, then maybe the best thing for you is to modify your lease to include them. If everybody's on board and he would otherwise qualify, then you kind of want to get him on the hook in the event that he is later the person who is, violating the lease, and you want to issue some kind of notice against them or assess damages against them specifically. So when else is speed required? You want to be speedy when it comes to violation. You definitely also want to be speedy when it comes to filing at the eviction court. Too many times landlords just wait and wait and wait. But I want to make sure that in your mind, you know the timetable. It's going to be about 30 to 45 days before they are evicted. And the truth is, a lot can happen in 30 to 45 days, so that if you've issued notice and they haven't fixed the problem, and then you file and they haven't fixed the problem, and then you get the trial notice, which is at least give or take about a week away, and they still haven't fixed that problem, chances are they either never will or never intended to. And so because of that, you're thinking, as you approach trial, it was a good idea that I filed it as soon as I did. Because even in the occasions where after you send notice to vacate, the tenant fixes it, the notice to vacate probably prompted that. Or maybe you filed and then the tenant comes to you and fixes the problem. It's probably because you filed. Or maybe you get a trial notice and the tenant comes and they fix the problem. It's probably because trial was coming. But if you never set these things into motion, it's unlikely that even a good tenant will be as quick to resolve the problem unless you are acting quickly. So speed is important, not just with notices. Speed's also important with filing. Go ahead and pull the trigger. The cost is not high. If you're doing it on your own, generally speaking, for one defendant, it costs under $150 to file. But if you're thinking in terms of rent and 30 to 45 days, if you've got, for example, a $1,500 rent payment, every 30 days is $1,500 lost. In 45, you've lost over $2,000. If you think in these terms, $150 is a bargain because it speeds up the process and hopefully gets the ship righted and everything finishes out on this lease as previously planned. But if we got to abandon ship, at the very least, you've limited your losses to 30 to 45 days. And that's always the goal. How can we make things better, or how can we stop things from getting worse? Speed is that answer. And then finally, whenever things go wrong with lease violations or with perhaps an eviction matter that's just going sideways, or maybe you've been sued for a repair and remedy case, maybe your tenant is accusing you of some other harm that they've experienced based on that lease, the best thing you can do is get help quickly. And whether that's coming to a landlord attorney or seeking out a group of other landlords or having a mentor in place, somebody who knows about landlord-tenant law, who can guide you. Don't feel shame or embarrassment or resistance to the idea of getting help early. If you are in unfamiliar territory, the worst thing you can do is try to learn on the job. I would say learning should happen in the off season. Learn about leases, learn about the law, learn about common things that tenants do before the problems happen. That way you can use that knowledge when problems happen. In the middle of a problem, get help, and get help quickly. Again, whether that's from a group, an individual, perhaps legal counsel, but get help quickly. The faster you do this, you're going to see a better rate of return. If you're spending money or just kind of finding good counsel, the faster you do these things, the better things are going to end up being for you.